get to hear our report by Claudia, which we were going to hear last time, but in the interest of time, we wanted to give her as much time that she needed to report on rule changes in other states. So Claudia, do you want to give us your rundown, please?
Thank you. I'm going to share my screen for a bit. Is everybody seeing the rule tracking sources?
Yes.
Okay. All right. How I approached this assignment was to start first by looking at what tracking resources are already out there for tracking rule changes, standing orders, and such. And in doing so, I found that there's not only one source you can kind of rely on. I ended up having to compile my own tool using various sources. So I thought what I would do is sort of take you through what some of those tracking sources are that exist, that are available to you, and then do a little review of what the information is that I found. Okay, so I'm going to start with the free internet available resources. And the first one, which we're all familiar with, of course, is from the National Center of State Courts. In collaboration with the Thomson Reuters Institute, they have created the State Information on AI resource page, which includes the state court orders, rules, and proposed rules tracker. And this particular tool provides a running list of links to various rules, orders, and proposals from state jurisdictions. The National Center also provides trackers in the area for court guidelines and policies, statutes, legislation, ethics and conduct codes, and more. The next item is RAILS, which stands for Responsible AI and Legal Services, which is hosted by the Duke Center on Law and Tech and is an open source collaboration with law firms, tech companies, and individuals. The AI in Court Tracker, originally live in March of 2024, aspires to gather and organize court rules, orders, and guidelines regarding AI. It does include state and federal jurisdictions. And I found Rails to have the most listings, and the Excel table that they present makes it easy to manipulate the data. However, I did find I was frequently felt compelled to verify these entries. Although predominantly comprised of federal court references, the ropes and gray standing order and local rules on the use of AI tracker does include some selected state court level information. This particular tracker tracks whether the rule or order applies to any AI use or only generative AI use, and to whether or not the use is cautioned if disclosure is required or if the use is outright prohibited. The tracker also distinguishes between rules applied towards AI use in research versus in drafting of pleadings. Moving on to some of the subscription sources that are available to us. LexisNexis provides several trackers through the Lexis Plus service, and with a Superior Court subscription, we have access to the Generative AI Federal and State Court Rules Tracker. And this tracker identifies the civil litigation rules, procedures, and standing orders implemented by federal and state court judges, court administrations, and bar associations governing the use of generative AI in court filings. These can be promulgated rules or commentary, standing orders, or individual judges' procedures. The tracker also includes ABA or Bar Association opinions. Lexis claims that the tracker is reviewed at least weekly and updated as needed. Lexis Plus also offers trackers, again, on legislation, and the State Law Survey tracks the enacted statutes. On Westlaw Classic, which is what we have access to in the Superior Court, we do have access among the secondary sources to the Artificial Intelligence Legal Material and News data file. This source offers a choice of several pre-generated search strategies. And these pre-generated searches include search all court rules related to artificial intelligence and search all rule updates related to artificial intelligence. Again, like Lexis, they offer also statutory and legislative tracking mechanisms. Although not a tracker, I did want to point out the Widener University Delaware School of Law's Generative AI and Legal Research LibGuide. The LibGuide is a good source for locating other trackers, articles, and resources on AI-related legislation, court activity, ethical issues, and news about the impact of AI on the legal profession. So having gathered from all these various sources, I compiled it into my own tool, and I'm able to report out on some number information. I do just want to stress that this is from the resources I was able to find. So since 2023, over 24 courts, about 27, have issued rules or standing orders regarding the use of generative AI. These courts are located in 8 states. If we expand to include courts and jurisdictions that issued guidelines or court policies, that number grows to about 47 courts or jurisdictions among 22 states and the District of Columbia. As to the timing of the issuance of these rules or standing orders, 6 of them were issued in 2023. In the first half of 2024, 7 were issued, and in the second half of 2024, they were issued from 10 courts. And in 2025, 2 have been issued so far. 2 orders did not indicate at which date they had been issued. Expanding to include the guidelines and policies, the numbers become in 2023, 8 issuances, the first half of 2024, 16 issuances, and the second half of 24, another 16 issuances. And in 25, 4 issuances so far. Again, 3 did not include any specific date. Some entries of note include several Texas county courts that have issued standing orders requiring the disclosure of the use of generative AI in court filings and provide a certification form that must be attached to the document certifying that the information has been verified and is accurate. Courts in California, Idaho, Illinois, New York, and Ohio also make disclosure requirements, some including a specific certification statement to be required with the filing. Judge Horan of the Circuit Court of Cook County, Illinois, Chancellery Division, requires the use of a large language model AI to be indicated in the caption on the filing, and failure to do so may result in sanctions. Few other courts do speak to sanctions for failure to comply with the compliance requirement, disclosure requirement. The Florida Supreme Court issued an amendment to Chapter 4 of the rules regulating the Florida bar. The court amended specific rules, including rules regarding competence, confidentiality, managing of lawyers and non-lawyer assistants, and added a warning about the necessity to take care in the use of generative artificial intelligence. The San Diego Superior Court issued an order stating that, quote, any person or entity who wishes to document, photograph, record, broadcast any portion of a court proceeding is prohibited from using generative artificial intelligence unless prior written approval, judicial approval is granted. Now, granted, that's for broadcasting. Moving away specifically from rules, some guidelines and policies of note include the Illinois Supreme Court Policy on Artificial Intelligence, which was released in mid-December of 2024, but became effective on January 1st of 25. The document states, quote, the use of AI by litigants, attorneys, judges, law clerks, research attorneys, and court staff providing similar support be expected should not be discouraged and is authorized provided it complies with legal and ethical standards. Disclosure of AI should not be required in a pleading. The rules of professional conduct and the Code of Judicial Conduct apply fully to the use of AI technologies. The Michigan Judicial Council Generative AI and the Court's Work Group report and recommendation was released in October. This document acknowledges that AI is already embedded in the practice of law and court administration and identifies the issues, benefits, and risks of the current use of AI and makes recommendations for the court to expand training and education on Gen AI, to implement pilot programs for Gen AI tools, to develop feedback loops and iterations of Gen AI tools, and to develop scaling and integration plans for the use of Gen AI tools. The Washington, D.C. Bar Association Ethics Opinion 388, that was issued in April of 2024, provides detailed information and discussion on the current state of generative AI and practice rules for that jurisdiction. It includes extensive discussion of the rules that practitioners should be cautious of, including the rules regarding competence, representation, confidentiality, fees, supervision of staff, and malpractice. It also provides a very good discussion on what an LLM is doing when it is responding to a query. It is not providing an answer, but rather responses that are statistical probable outputs to the query. The New Jersey Office of Administrative Director of Courts issued a notice to the bar stating, quote, "The core ethical responsibilities of lawyers, as outlined in the rules of professional conduct, are unchanged by the integration of AI in legal practice, as was true with the introduction of computers and the internet." The Rhode Island Supreme Court Executive Order number 2024-03, issued on October 22nd, established a committee on artificial intelligence and courts and asks its steering committee and its subcommittees to address the impact of Gen AI on professional conduct, on judicial conduct, criminal law and evidence, and civil law and evidence. And the committee shall submit a written report by June 30th. The Supreme Court of Delaware interim policy on the use of Gen AI by judicial officers and court personnel was issued on October 21st. This policy requires judicial officers and court personnel to comply with the interim policy on Gen AI that was recommended in 2023. The policy addresses the responsibility of the use of Gen AI by the authorized user, the need for informed use of Gen AI by the authorized user, that the authorized user's decision-making cannot be delegated to the Gen AI, the use of Gen AI must be in compliance with applicable law and branch policies, and non-approved Gen AI may not be used. And the last item I just wanted to point out that I thought was of note was the Kentucky Court of Justice Generative AI Intelligence Standard. Standard became effective on March 1st of 2024, and it has a future required review date of March 1st, 2025. And personally, as a researcher, I find having this review date very helpful for knowing that this information I'm finding is accurate and has not gone stale. And that is all I have at this time.
Thank you, Claudia. That was very extensive. Does anyone have questions for Claudia about any of the areas that she touched on?
I'm kind of curious, after seeing sort of all these different orders coming out from different jurisdictions, if you're seeing a trend?
Yes and no. There seems to be a split. There are, as sort of came out in this, there are some states and jurisdictions that are being very specific of, no, you have to disclose it. You have to have this certification. It must be attached to every filing. And then you go to the other extreme, like the Illinois, which is saying, nope, it's just there. It's part of the practice. We're assuming you're going to follow the rules. I don't know if you read any of the newsletters that come out from 360 or other types of publishers, but you'll notice there's a lot of articles coming out lately of individuals still failing to verify, running afoul of the rules of practice, and sort of being brought, if not actual sanctions, at least spoken to from the court regarding that. So there's a split of some who are saying we have to have it disclosed, and others that are just, nope, let it go. It's just there. As New Jersey said, it's like computers and the internet. Just learn to use it properly.
That's really helpful. Do you think, in seeing the split, are there certain courts that Connecticut finds themselves more aligned with that are saying like you said, New Jersey and Rhode Island both are saying it's already in the rules. I'm just curious if we can glean anything based on where those courts are located in the country.
Yes, I mean, I don't have that for you right now, but as I said, I created sort of my own tracker. I could certainly go through that and run a sort of filter and try to extract that type of information, again, from the material I've gathered.
Thank you so much.
Any other questions for Claudia? Has
Melissa.
anyone, oh, who's there?
I'm sorry, Melissa has her hand up.
Go ahead, Melissa. Oh, you're on mute.
I thought that the presentation was really helpful, Claudia. Would you be willing to share it with us?
Sure. Do you want just the slides, or would you like the listing with links of the resources that were utilized?
If you're willing to
Or
share
both.
both, that would be great.
Yeah.
Thank you.
Sure.
In your research, Claudia, has anyone started to kind of compile the benefits and the negatives to having a rule or not having a rule?
I didn't find anything that went that far in discussion, but then again, that would be more likely in articles or studies, and I was focusing on the rules and standing orders themselves. So that's another thing I could certainly look at for you.
Just something to point out as we talk about rules. AI is developing so fast and it's changing its complexion in so many ways that jurisdictions that have implemented rules have found themselves suddenly having to reinvent things very quickly, type thing. We're seeing new uses for AI, not only coming out in terms of research or generating documents and briefs and things like that. I heard about a program that you can put your phone on if it's got the AI feature, and it will take down a trial and synthesize it into a 2-page brief of this is what was presented and these are the sort of the highlights type thing. So lawyers are starting to say, well, this is a tool to help. And I think we talked about it, I think Elizabeth did last time, about the pressure for the private bar, where clients want it done cheaply and effectively, and having associates and things, research is antithetical to that. So I think we've got to be careful about what kind of tools we're using because they're coming fast and furious.
That's a good point. And obviously, it seems what Claudia has told us is that different states have taken it to different levels, whether it was a rule or a guideline, whether it just required the disclosure versus the verification of the item. So there's a lot of different ways that it's been approached that I think we should think about if we're going to try to do something with our committee as far as recommendations, which might be the soundest. And I think I agree with Melissa. If you share that with us, Claudia, maybe we can all review it so we have some idea where we want to go. Any other questions or comments about Claudia's presentation today? And I'm terrible on Teams knowing who's wanting to talk, so just feel free to speak.
Hey, Claudia, this is Ratish. Great presentation. We already requested if you could send a copy of the content that was just discussed. I wanted to stress on the data governance part, right? So where the data is being accessed. So I'm going to take a look at the document itself, because I think that's one of the best ways for us to protect. So if we have our data, we could perhaps come up with policies saying, hey, this data can only be accessed on certain machines, in this case, judicial branch workstations and laptops. So I would stress on that when you send that document. I'll take a look at it.
Thank you, Ratish. Yeah.
Yes, thank you. Anyone else? Lucio, can you see better than I?
No one has a question?
Okay. So that means, and again, thank you, Claudia, for a very nice presentation. It's demo time by Lucio and Dibby.
Yep.
Lucio Dibi and Ratish will be.
Oh, Ratish too.
Yeah, we added Ratish. He gives a good soundboard to our security posture. Yeah, so, you know, a simple demo. We, as you know, the judicial branch has the other internal AI committees that are trying to approve products for testing purposes to use and to evaluate and so forth. But in the meantime, we three got together and we said, you know, what's out there real quick that could, you know, maybe provide efficiencies and within the branch and to help maybe patrons and litigants and so forth. And we just simply thought of maybe the Connecticut practice book. It has all the rules, and you know, SRPs would be asking and attorneys would be asking questions and so forth, and trying to do research. And so this would be a prelude to our chat bot that we may put on the Connecticut Judicial Branch website, which is something the Chief Justice, I know, was interested in having. And so we had ChatGPT ingest the Connecticut practice book. And with that, we said, okay, let's come up with a few practice questions just to see if somebody were to come into the law library or the court service center and might have a question or what have you. You know, let's see what kind of answers it would provide. And so we came up with a few questions. Did you want to put up those questions real quick? We'll pick a question. Yeah, like an SRP question. I cannot afford an attorney. May I represent myself in court? Maybe something, Claudia, that somebody may ask a librarian. Or I represented myself at small claims hearing. How long does the court have to issue a decision? My attorney requested that I pay in cash for legal services rendered. Is this legal? Can my spouse and I have the same attorney representing us in our divorce? Things like that. And maybe an attorney may have a question as well. You know, one of the four there, you know, I'm an attorney admitted by ProHack Beach in Connecticut. What's my requirement with respect to Connecticut client security funds? And on and on. So I don't know, Dave, you want to pick a question? Or Justice Alexander, you want to, any of those questions may seem?
No, you don't want me to participate in a demo, so I'll leave it to you guys.
Okay, Debbie, which question did we have?
I'll use this to start with. Let's remove the number.
So this is the response. As you can see, it goes into not only a quick answer, but it goes into the rules and it cites the rules and the sections, and then at the end it would give you probably a little synopsis of what a summary of the question, of the answer rather. And it also refers you to the statewide grievance committee if you're really concerned about something that an attorney asks you, like paying in cash, et cetera, et cetera. So I think it provides, you know, a multitude of varied answer to a question that might come to, again, a librarian or a court service center, or, you know, if we had a chat bot on the website, somebody from their home could be typing this in and getting an answer, you know. And we also did some research, and we found that ChatGPT isn't limited to, of course, the English language. You can ask the same question in another language, and it'll come up with the same answer, and, you know, translated. And Dave, you're going to do Italian? Okay. Okay, the question, my turn. Okay, and let's see. Il mio avvocato mi ha chiesto di pagare in contante I servizi legali ressi. È legale? And then it gives the answer. And same answer pretty much. And so, we have an interpreting question that a concern may be resolved with this as well. So just thought that it was very interesting. These are resources that very easily at some point, once we approve the software and funding and so forth, that we could enhance and the judicial branch. Any questions? No. Did we want to go? Does anybody want to test it and have a question offhand for the practice book?
This looks great. I think for access to justice, the use cases you just mentioned, especially in Spanish, would be super helpful for individuals to be able to access.
Oh, yeah, very easily. And the Chat GPT also has a voice recognition, not voice recognition, but you can ask the question verbally in Spanish without even typing it, or in Italian or English, and it will automatically interpret it and create the answer and put it on the screen. Yes, Judge.
So this is a large language model that is drawing these answers from the existing practice book. Yes?
Yep. Yes.
How do we know that the answers are legit? I mean, because we've seen generative AI where they've created cases and things like that. And so as a user of this, if I put this in, how would I know the veracity of it?
So, and again, this is using ChatGPT, but when we create our own chatbot and anything that the branch would put out there for use by patrons or litigants, we will, and Ratish, correct me if I'm wrong, we can guide it to say only use these resources when answering this question. We can create canned questions and answers for it to respond. And so you can control it that way. It's not going out on the internet to get these answers. We, like I said, we had it ingest the entire practice book, and these are the answers it's getting from the practice book, and it's putting it and formulating in practical terms, in arguments, in subsections, and in table in formatting and so forth. So it's amazing. Anybody want to test with a question, PJ?
So, Lucio, I like the idea of doing it internally. I don't know if anybody here attended the National Center's webinar in February, I think it was February 19th, where they came back a second time to talk with folks from the People's Law School of Canada, which is a nonprofit that assists with legal aid, and the company Tango Work that they've worked with in order to create an internal chatbot to do exactly the kind of thing we're looking at here. And Lucio, like you said, to a great extent, what they found was the fine tuning of the information that got fed in. Person X asks a sentence, but they were looking at behind the scenes. They're then feeding in a whole lot of other relevant information and guiding the chatbot to the location to look for that answer, so that it can be. What they found was they dramatically increased the proportion of correct answers and dramatically decreased the proportion of wrong or not appropriate answers. They were also able to make it phrase things so that it wasn't giving legal advice, which I thought was really interesting, as they were looking to provide guidance, not legal advice. So I like where you're headed, where JS is looking a lot here. I'm wondering though, there's another train of thought, which is how do you get your information? Because we've got tons of information on our website. How do you fine tune the information that's out there so that the people who are not going to come to our chatbot, but are simply going to log into ChatGPT on their phone and type in the question, end up getting back more correct answers from the data that we have on our website. And I don't know if that's outside the purview of this committee, but that fine tuning of the information that we have seems to be a parallel path that's really important.
So yes, it is outside, but I'll tell you real briefly that our law library web board committee, our web board committee has already started to address that. And what we think is that Microsoft Copilot, once it's configured and by Gratish's team and provided to the branch, it can go out there and do some of this prep work for us. It'll go out, find all these outdated pages. You know, when was the last time the page was updated, et cetera, et cetera. And then once we gather those statistics and stuff, we can provide that to subcommittees of business. You know, all the units within the branch can look at their own pages and see and update and make sure things are correct and you know, and maybe just update it that way. And then our chatbot will have the most up-to-date information that it could possibly have, you know, to perform these functions.
Great.
Debbie, did you have anything?
Yeah, I think what we did, this is fairly a simple use case, because what we did is ingested 3 documents. We actually ingested the probate, the practice book, and the evidence, the code of evidence. So we ingested 3 documents, some 1,000 pages, and it's very it's grounded to those 3 documents. So the answers that are coming, and then when I was working with Lucio, he suggested, can we ask it to cite the rules? So we gave instructions in very simple language. This is very easy to do. And we said, yeah, mention the rules from where you are getting that. And we can work, we didn't spend a whole lot of time. But regarding our website, there are ways like how we have done. It's going very technical, PG. I can explain you in a different meeting. There are ways to keep information in the website that are there, but that are archived. That means things that were published during COVID is there on the website, but the LLMs are ingesting those and giving people advice based on rules that exist on our website, but they are no longer relevant because of it's outdated. So there are rules how we can instruct external GPTs, external LLMs who are coming to our website and indicate what is current and what is there as archived. So that would need some work on, and that's why Lucio mentioned that we probably will end up, because the license that we are getting for the Copilot works on our GCC. So we might get the website into our, we can talk about the technological part later on, but this approach is relatively simple. Again, somebody from the public can, we created a Connecticut practice book GPT, a separate GPT, and preloaded these 3 documents, but anybody can actually have a paid or free chat GPT account or anything for the case, and then upload these 3 documents and have this AI base the answers on the uploaded document. It doesn't have to be a legal document. It could be something else too. So the LLMs and the available AI chatbots are capable of doing those. Ours would be more in trying to control those and ground them to our law, not a neighboring state law, or not a different state law.
Thank you, Debbie. Gratish?
Yeah, so like Debbie already mentioned, anyone can do this today, right? If there's a document that's available on the public, some sort of a public domain, anyone can download PDFs, XMLs, JSONs, text files, and then take that and dump it into either ChatGPT or any model that, I mean, there are models out there which talks to multiple models, right? So there's Gemini from Google, Grok came up with, Twitter, Elon Musk came up with Grok. So there are models out there who's capable of training the data that's uploaded. You can upload like 100 GB worth of PDF files and just say, go and learn, right? And at that point, it'll basically go start learning. And it could eventually tell us things that we wouldn't even, you can ask it questions like, okay, can you tell me some logic that I haven't even thought about, right? Obviously, after chatting with it for about like an hour. So that's something that obviously we are exploring. Obviously there's funding involved in it, there's compliance involved in it, because Anyone could, I can say, you know, I'm a qualified individual to answer all these questions. But the moment you put that on a judicial branch website, that's what gives it that legitimacy. That's when, you know, even the members of the public are going to trust that, okay, now I can rely on this. And so that's one of the most important point. And to talk about Microsoft Copilot, it's going to be really, really simple. You're going to have a UI with a tab called Work and a tab called Web. So all our users have to do is to click on the tab Work. At that point, you're tapping into, or you're making a connection. It's like one of us opening our Outlook in a judicial branch website. That's all the data that it knows about. It knows the attachments that you have received, and it will make sure through data governance, it's not going to leak that data. So for instance, if you're going to take some stuff from Work and try to upload it into a public domain, the data governance piece is going to block it. You're not allowed to do that sort of a thing, right? But if the branch decides to open up the web portion of it, then users can research, you know, they can research and they can find out. Again, we're going to have all the checks and balances in place. Users will have an opportunity to use that web version of Copilot to do their own research. But the moment you click on the Work tab, that's when it's going to start connecting to your Outlook, SharePoint, which, you know, the AI committee approved on, and we are in the process of testing that. It's going to be a collaborative approach.
Yeah, definitely. Debbie, you have something else?
If I can, I'll just add that what Ratish mentioned, Microsoft Copilot relies on OpenAI models, one of these. As Ratish mentioned about multi-model AI, Perplexity is known for using multiple AIs, and I understand they're also using DeepSeek. But Microsoft Copilot is basically telling us that they're using OpenAI models, and they're also not going to, they're going to keep everything that somebody uploads within the Microsoft GCC environment. It's not going to leave the environment.
So for internal use, of course, to aid judicial branch, you know, there's so much that we can do with Copilot that we believe we can do. For instance, Cindy, you know, if we had it ingest all the prior memos that legal services has in its filing cabinets and so forth. I mean, you can do searches and so forth for HR. Same thing with their files. If we digitize their files, and so there's just a myriad of ways we can provide efficiency within the branch. I think you know, AI is just a wonderful, again, a tool for everyone. But that's all we had, Judge.
Excellent. That was really an informative demonstration, and you guys did an amazing job. And Ratish, I would just say, I don't think anyone can do this, and I'll speak for myself first, but you did a great job explaining what people can do if you have the information.
Thank you, Judge.
So we have next steps on our agenda, and I spoke briefly with Lucio, and we both looked at each other and said, we don't know what to say our next steps are. So what I think Lucio and I would like to do as your co-chairs is see what other committees are doing. I know that rules, perhaps access to justice. We had another AI committee, a working group, and kind of compile that for us, because eventually we are going to have to make certain recommendations coming from this committee to give to the judicial branch. So I really can't define next steps yet, but I promise you we will try to get a definition to you sooner rather than later, and that will also inform the date of the next meeting. Are there any other questions or anything else before we adjourn for today? Luch, you see anyone?
Nope.
All right, then we are adjourned for today, and we will be back in touch again with you soon. Thank you again for your participation here today. Bye-bye.
Thank you.
Have a good day, everybody. Thank you.
Bye.